Welcome everybody to the third and final panel session for this afternoon. My panel is so eminent, I'm not even going to comment on her. And given the time, I'm going to go straight into simply introducing them. So in the order in which I hope they're expecting to speak, we have Colm O'Cinneide. Colm is Professor of Constitutional and Human Rights Law and Vice Dean of the Faculty of Laws at UCL. And as you'll all know, he writes widely on constitutional law, quality and discrimination law, and of course, human rights law. Our second speaker in this session is Katja Ziegler. Sir Robert Jennings, Professor of International Law at Leicester, co-director of the Centre for European Law and Internationalisation, and of course one of the co-conveners of today's event. Katja writes widely on international, European and comparative law, and recently published a co-edited collection, I think in German, but the English title is Democracy Asserting Itself, which I thought sounded like a very good title indeed. And then thirdly, Merris Amos. Merris is Professor of Human Rights Law at Queen Mary University of London and Director of the Human Rights Law Centre there. And her expertise ranges across human rights law, both at the national and international levels, with particular focus on Human Rights Act and the ECHR. So to begin, I'm going to hand over to Colm, who's going to talk about the past, present and possible futures of multi-layered rights protection in the UK.
Great. Thank you, Mark. The title of my paper is, of course, insanely ambitious and is basically offering a multi-volume book project. Not that I'm writing it, I'm just saying if I were. And so I'm going to obviously have to condense massively. In condensing, I'm conscious that almost everyone in this room will be very familiar with the past of rights protection in the UK, and to an extent, familiar with the present controversy surrounding multi-layered rights protection in the UK. So I'm going to focus to some extent in the second half of my talk on possible futures. And this is going to be a bit blue sky, and it's going to be a bit speculative and not as rigorously doctrinal and or conceptual as I'd like to offer. So if I'm sounding a little bit speculative, it's the nature of things. So just let me get that apology in our excuse in advance. Let me begin the past of multi-layered rights protection in the UK. As you heard this morning, the European Convention was established, as Katja put it brilliantly, to prevent dehumanization, reinforce constitutional resilience, generate a rights orientation across European society, and it reflected the post-1945 emerging global consensus that the insulated spheres of national sovereignty cannot, and should not be paramount when it came to decisions about the lawfulness of rights violations. Okay? And we all know that's why the convention was established. We also all know that this convention project was, to some extent, viewed with a certain detachment, perhaps is the best way of putting it, but from the UK's perspective, because of course the UK's history, and in particular the fact that it never collapsed in the 1940s, meant that the UK in a way saw itself as being slightly detached from this continental European project of reinforcing rights resilience. And there's been a lot of literature, mainly blog posts, but also some interesting policy exchange papers produced in the last couple of years that sort of emphasize that have emphasized this UK's detachment, and sort of, various quotes from Labour ministers in the 1940s being very skeptical about this convention business and so on. I think in noting this skepticism, which has been highlighted in that literature quite recently, I think it's necessary to emphasize that detachment can be overstated. And Ed's book, already mentioned this morning, just gives a wonderful historical overview of this. But the past of UK commitment to multi-layered rights protection in Europe has been a past featuring much political grumbling. But when the chips are down, the UK repeatedly took a decision to commit to the developing multi-layered framework. Okay, so the UK was in at the beginning of ratification of the ratification of the convention, establishment of the court. It accepted the court's jurisdiction a good 20 years before France, for example. It had many of the most controversial decisions of the court in its first few years. It accepted them, it implemented. And this is why when I see this literature emphasizing the UK's detachment and the grumblings of assorted historical figures in the UK, I think it's also quite important to actually look at what happened when the car hit the road, so to speak, which is that the UK, for all its political constitutionalism and for all its fundamental commitment to parliamentary sovereignty, was actually actively involved in the creation and establishment of the European multi-layered project. I think it's important to emphasize this, bearing in mind the creation of the convention system of rights protection was always intended to be a gradual building up process which shifted and changed over time. When people give out that what the court does now is out of line with original the intent of the original framers, it's always interesting to go back to what some of those original framers were saying. Is Danny Nicol, for example, a well-known UK political constitutionalist and no friend of the convention, pointed out in a public law article in 2003, the French delegate to the drafting committee cheerfully said, the convention and what's understood by rights protection will obviously develop over time. Okay, and of course, the convention mechanism is really interesting because states for decades only accepted the jurisdiction of the court for 3 years renewable period. So, you know, the UK, like everyone else in the Council of the Eurozone, could, of course, at any point from the 60s through to the mid-90s, have withdrawn from the jurisdiction of the court. It could have withdrawn after Golder, it could have withdrawn after Handyside, it could have withdrawn after the Gibraltar killings case, etc., etc., etc. But it didn't. It stayed on board, and in the mid-1990s, it told the Central and Eastern European countries to be respectable members of the European community, you have to sign and ratify this convention business, and it accepted the permanent jurisdiction of the court. Okay? And to top it all off, there was a general election in 1998, and incorporation was a manifesto commitment, which was locked in. All right. So when we emphasize this tension, historical tension, which you all will know, which I'm not saying doesn't exist, there's both the detachment and also the historical tension between a constitutional system based on a largely political constitutionalist bent and parliamentary sovereignty, dealing with a supranational adjudicatory mechanism. You all know that tension was part of the past of the UK's relationship with multi-layered constitutionalism, but it's also very, very important to recognise that the UK was an active builder of this multi-layered system of rights protection, and repeatedly the political decision was taken to integrate within this mechanism. Okay, and that's important, I think, to emphasize. That reflects, by the way, a very important aspect of UK political constitutionalism, which is to say that, you know, there's always been an emphasis internally within the UK on the ultimate decision-making on matters of law and rights and everything else lying with elected politicians in Westminster, but that such elected politicians would always use their final powers responsibly, with one eye on civil liberties, rights, and other important values, and with one eye on the UK's international commitments and what was good for our international order. So, as my UCL colleague Richard Bellamy likes to emphasize, a prominent theorist of political constitutionalism, there is nothing in the UK's constitutional commitment to political constitutionalism, so to speak, that was incompatible with this active role in building up this multi-layered European constitutions. Now, when I say it's nothing incompatible, there's obviously an inevitable tension in a system prioritizing political decision-making, having to deal with a court taking human rights decisions. But as Richard has correctly noted in his writing, the concept of UK political constitutionalism that used to be applied, that used to dominate UK constitutional thinking in Westminster and more generally, was to recognize that these tensions could be managed, that ultimate decision-making would rest in Westminster, but that the relationship with judicial human rights structures within the EU or ECHR frameworks or other mechanisms could be managed, and that this tension was something that was just part and parcel of ordinary governance. That was the past. We're now in a very different present. The tensions have been amplified in the since 2010, since before that with the prisoner voting rights controversy. So the tensions that have always existed have been irritated and grown more prominent. But in addition, I would argue that we've also seen a quite fundamental change quite recently, which is this idea that from a domestic point of view, that the idea that that UK parliamentarians using their sovereignty, so to speak, should endeavor to try and maintain fidelity to the framework of regional international human rights law instruments, because there was value in being part of this norm generating, norm reinforcing international process. That concept has been radically undermined and radically transformed in recent years. And I think nothing makes this more stark than David Wilson, as Shadow Attorney General, the report he prepared for Kemi Badenoch as leader of the opposition, recently for the Conservative Party conference. Because if you've read the report, you know that formally that was set up as Kemi Badenoch as the leader of the party asking David Wilson, as Shadow Attorney General, I have policy objectives: immigration control, ending legal harassment of British troops, promoting economic growth. I have policy objectives. Does the ECHR get in the way of these policy objectives? David Wilson said yes. Therefore, the Conservative Party said, okay, then the Conservative Party decided, well, we're leaving. Now, what's significant about that is that tensions between politicians wanting to implement their political agendas and the requirements of international human rights frameworks have always existed. They've always been recognized. But within the framework of a domestic political constitutional set of arrangements, locked within a wider, more legalized, judicialized human rights architecture, that tension has been managed. Successive governments have said we will go and try and achieve our policy objectives while still endeavoring to maintain conformity with Strasbourg, with international human rights law more generally. But the setup of the Badenoch-Wilson analysis actually repudiates that way of approach. It marks a quite dramatic shift where international fidelity to the multi-layered system of rights protection is deemed to be subordinate. It is deemed to be something that can be jettisoned and that should be jettisoned if it proves to be a major irritant in achieving domestic policy goals. So I actually think it marks quite a symbolic, I won't call it a constitutional moment, but it's certainly quite a symbolic political legal moment where that attempt to sort of reconcile political objectives with international human rights frameworks is jettisoned in favor of radical subordination of the ECHR and international human rights law more generally. And it's and we all know, everyone in this room will understand the political dynamics that's driving this process. It's worthwhile pointing out this isn't, of course, just something that's happening in the UK. All over the liberal democratic world, we're seeing a resurgence of an emphasis on an increasing emphasis on national sovereignty, national assertiveness, an increasing concern that the perspectives of majorities and the policy wishes of majorities are being unduly hemmed in by technocratic or legal decision making. This is happening in state after state after state. often underpinned by an emphasis on not just the will of majorities, but also majorities viewed in a particular ethnic way. But we'll skip over that particular. So this isn't a process that's just specific to the UK. This is happening in country after country and state after state, which is why disgruntlement with the ECHR is becoming a feature of European politics in state after state, including states like the state where I'm currently semi-resident, where criticizing EU institutional structures would have been completely unknown until 2 years ago. And now the Belgian government, for example, is one of the group of 9 who signed the letter criticizing current jurisprudence. So we're seeing these global trends. They're just amplified in the UK, first of all by the native tradition of Euroscepticism, but secondly in this very, very strong deployment of political constitutions and the way that the old constitutional tensions are now being, if you want, made the focus of systematic sort of attempt to jettison the regional multilayered system. Now, this raises rather interesting questions, obviously, about the future of rights protection. And here's where I come to my less analytical, more speculative part of the paper. I'm just going to, in the time available to me, I'm just going to throw out, sketch out a couple of available futures. One future is that the current moment passes, that the current political tension surrounding the ECHR and the UK's embedment in this multi-layered framework actually disperse. If, for example, the discussions about reform of the ECHR produce some sort of mechanism that European governments actually start going, okay, this is fine, and move, and that encourages greater engagement on the part of the UK, less antagonism, the Strasbourg mechanism. Our politics simply shifts. Things may change. My own sense is that that's unlikely. My own sense, and I hate to be pessimistic, is that when we are now in a situation where across the political right of UK politics, hostility to the ECHR is increasingly being viewed as a marker of political loyalty, of being a member of the political tribe. And in particular with discussions of Tory candidates for the next general election being required to commit themselves to ECHR withdrawal if they're to be selected. Nothing more viscerally illustrates the way that this disengagement push is becoming a marker of political loyalty. And that's inevitably going to make it very, very difficult for the UK to remain a committed and good faith member of the ECHR if half the political spectrum is beginning to view that as a marker of, as something politically intolerable. It may well be that we have a situation where the UK, where a future conservative or reform government, whatever shape, exits the ECHR, and then the next Labour government or whoever goes back into the ECHR, which is a much easier process to achieve than Brexit. So we may yet see an in and out dance, but that is inevitably going to have an impact on the status of the ECHR. I think that's inevitable. What's also interesting, though, and I'll finish these points, and I'll finish with this, is the question about how domestic law will play out. The Woolston report is very skeptical about retaining the HRA in its current form, also quite skeptical about having a Bill of Rights, perhaps with fingers burnt from conservative experiment in trying to identify a workable HRA/Bill of Rights mechanism over the last decade. There's lots of talk about falling back on old common law mechanisms, legislation and common law bearing the brunt of rights protection. Mark asked a very interesting question earlier about, perhaps there should have been sorry, Mark, this isn't the question you asked, but in raising the point, you did raise the point of whether the othering of rights protection in the UK has been a problem. There might be something to be said, of course, there's lots of potential common law rights protection, but of course, any future common law rights protection in the context of disengagement, at least, towards the ECHR will be carried out under a shadow of a generalized pushback against rule of law protection, against the role of courts in protecting rights, a new emphasis on judicial deference. So I think that's a very important point to note in terms of future of rights protection. We are seeing a big new push, not alone towards the development of native standards, but more intensively towards a dilution of rights protection for rights more generally. Last night in the House of Lords, an amendment was tabled to the Border Security, Immigration, Asylum Bill, looking for an ouster of all judicial review of any immigration and asylum decision. So we go back to the old days where the Home Secretary, as an individual, took all decisions, maybe with the benefit of an internal appeal panel. That was defeated, but it was put to the vote. That's where I think that's one, I think, potential future that's moving up, a rather radical repoliticization of rights protection. In a way, by the way, it's quite different from how things used to be handled in the old days of the historic political constitution, where politicians used to pride themselves on their restraint in this area. There's also, I think, big issues, but time is out. I think there are very interesting issues as to current legislative proposals being tabled by Reform and the Tories involving deprivation of indefinite leave to remain status, potential deportation of children back to Afghanistan, female children in particular. And many of these proposals are no sooner being articulated than they're almost collapsing under the weight of the human rights and ethical difficulties involved in some of these. But it is interesting to note that this is where we're at. We're seeing, I think, in tandem with this politicization of rights protection, we're seeing a radical shifting of the Overton window in terms of how UK politics relates to this wider world of multi-layered human rights protection, which increasingly is having much, much less purchase in increasingly radical ways. Thank you very much.
Very much for that, Colm. We're moving on now, just whilst you get to slides, up to Katja, and Katja is going to talk about constitutional resilience in layers, the multi-level dynamics of human rights protection.
Thank you, and yeah, thank you also for reading already out my title. I'm going to talk briefly about, and this links quite very well with Colm's, although, well, if everything he has projected comes true, then this will not help us. But so I'm going to talk about what do we mean by constitutional resilience, also because we're thinking of this is a part of a project, and conceptual terms and what we're talking about is important. Then the constitutional design elements that they contribute to resilience, then looking specifically on at the UK, and if there's the time, I draw out some wider considerations about the transnational dialogue that might support or undermine constitutional resilience. So the systemic perspective. So so I need to close things here. Andras Jakob, the Austro-Hungarian jurist and also current Austrian judge on the European Court of Human Rights, distinguishes or defines constitutional resilience in his work as a combination of constitutional design, the political, social, and cultural context, and the interaction between the two. We have talked very much about the context, the culture, and that constitutional resilience without that is not possible. We have talked less about the design. The design is not a silver bullet. The design may even be the lesser of the elements of constitutional resilience, but it's nevertheless important. It may, if anything, buy time, and time can be of the essence for rebuilding constitutional resilience. And of course, the interaction between the two is the third dimension. I'm going to focus mainly on the design aspect. in general, just the sort of things in mostly in codified constitutions, but not only, that we can talk about when talking about design elements are term limits, the regulation of political parties, funding rules, provision of parties. But high up in the list come international and supranational legal requirements, federalism, entrenchment or hierarchy of a multi-layered constitution, proportional representation, the independence of the judicial system, and the combined effects of constitutional actors and networks which mutually support one another, and rules on states of emergency. And so that's in the abstract. An example where constitutional design element or design factor was resorted to, and we talked, Angelika Nussberger talked somewhat about the AfD in Germany, was a recent constitutional amendment of the German constitution that was passed in December. So before December last year, before the February elections, where there was a concern about radical right-wing parties gaining a blocking majority potentially. So this statute was passed in anticipation of a situation where it would no longer be possible to pass the statute, and the aim of the statute was to protect the judicial independence of the federal constitutional court, the judges, appointment procedures. So direct reference, actually the explanatory memorandum refers to experience in European countries, so direct reference to Poland in particular, but also the statement to remove these sorts of issues from day-to-day political debate, from simple majority. So all the rules that are moving into the constitution were previously just in the statute, even though the Constitutional Court is a constitutional organ. So making it safer, so to speak, and with the explicit reference to what to experience elsewhere. So entrenchment. Constitutional design in the UK, we had some comments on this earlier. I would just like briefly to restate them. I would describe the design elements as structurally weak. So I think Robert Spano referred to this, but it's not just me or him, and we're not, well, I am British, but it also was the finding of the House of Lords Committee of the Constitution that referred to the flexibility as strength, but also as making the Constitution vulnerable to erosion and challenge, and in particular referred to a strong reliance of individuals basically being the good guys and complying with constitutional conventions. So this was in the report that was of January of this year, executive oversight and the responsibility for the UK constitution, which is in itself a remarkable exercise, I suppose. So it's structurally weak due to the unwritten nature, but also in a state of flux. State of flux is also a vulnerable situation. So we have, and the state of flux is in particular triggered from the post-Brexit rearrangement of the human rights framework, where one layer breaks away, mostly. Yeah, so gaps post-Brexit, gaps and remedies that previously existed. Some commentators have suggested that the membership to the ECHR and the EU kind of stifled internal domestic development, glossed over it. There was no need. Positively framing, one could say, actually it allowed a way forward in human rights protection that was compatible with parliamentary sovereignty, because of that international dimension. The third, I guess, design factor we're looking at is that we went through a period of extraordinary policy decision, not just Brexit. I just put some statutes here that all were seriously flawed from a human rights perspective. The first one, perhaps more generally from an international perspective, the things like the Rwanda Plan, the Illegal Migration Act, the Northern Ireland Troubles Legacy and Reconciliation Act, all went very far in restricting human rights, or in part abolishing, ending the ability to rely on human rights. So, and I'm but going further into the sort of constitutional design model in the UK, but this is all familiar. The model we have here is a hybrid model, which incorporates through the Human Rights Act, the ECHR. One could say the Human Rights Act is our Bill of Rights and domesticate in that way, but that's not how it's generally perceived. So we have, I think, a genuine domestic and underdeveloped domestic protection, either symbolically or real. But the difference may not matter that much if the perception is there. But and this is largely driven to the through the post-Brexit constellation, but not only. There's also an asymmetric protection, and I'm going to say something briefly about this. But basically, the argument is this asymmetric protection could perhaps be a catalyst for a more resilient, wider human rights protection for the whole of the UK. So the two scenarios are the Windsor Framework, the post-Brexit human rights protection, and the devolution context. So briefly, in the Windsor Framework, EU human rights. So the Windsor Framework is the part of the withdrawal agreement, the agreement in which the UK exited from the EU, the part that applies to Northern Ireland. Yeah, it used to be called the Northern Ireland Protocol. So EU human rights continue to apply under this protocol, under the Windsor Framework, for any EU law, of course, that applies under the Northern Ireland, under the Windsor Framework. So in market rules, etc. But for our context, perhaps more interesting is the Article 2, Paragraph 1 of the Windsor Framework, the non-diminution of rights clause, which refers in a chain of references to the Good Friday Agreement and to the ECHR, and lays down a guarantee for those in Northern Ireland that there should be there shall be no diminution of rights as a result of the UK's withdrawal from the Union. And it refers to the Good Friday Agreement chapter on rights, safeguards, and equality of opportunity, which then refers back to the ECHR. But so what we have here then is a divergence, fragmentation, and asymmetric protection, which can be as arbitrary as which depends on where the person invoking the protection is. Yeah, and this has been manipulated, you could say, by moving migrants around that could perhaps in that could invoke protections in Northern Ireland under the Windsor Framework, but not if they are, let's say, in Liverpool or south of the further south. But in principle, so this is the Northern Ireland scenario. This goes a bit further than the asymmetric protection in the devolution scenario, in that where EU law is applicable, including that chain of human rights, there's also a remedy of which goes further, this application. In the devolution scenarios, that is not the case. So in devolution has allowed the UK, has allowed devolved governments to incorporate international human rights treaties if they in the areas of competence. So far as I can see, that has only happened for the UN Convention on the Rights of the Child, but it has been widely discussed and prepared actually for socioeconomic rights in Scotland. But with the rights of the Child Convention, we see this materializing. That's the first case that came through. So my interest, and this is all very interesting, I think, but my interest for our session is really how might this shape the protection of human rights in the whole of the UK. So just a brief snapshot on the Northern Irish examples here. The first case, Dillon, has been heard in the Supreme Court in October. So this is a case where Northern Irish courts were, first the High Court and then the Court of Appeal was called upon in the context of the Northern Ireland Troubles Legacy Act, so which intended or to put an end to all inquests, everything that had, for example, inquests into the deaths or disappearances of people. So Article 2 rights, ECHR were affected, and others, a broad range. So the key is that under the Windsor framework, the Northern Irish courts have disapplied the Act. Under EU law consequences, direct effect and supremacy, and in parallel, of course, also issued the Declaration of Incompatibility. Now, the Dillon case is still relatively local to Northern Ireland, but the principles are equally relevant for other contexts, in particular the Illegal Migration Act, which had parallel challenges in Northern Ireland with the same outcome, disapplication and Declaration of Incompatibility. So what does that mean for the protection of human rights in the UK? So we could easily see a scenario here where Northern Ireland has a much more favorable status. So that somehow cannot be, I think, in one country. Yeah, that's a serious challenge, I think, to the uniformity of rights applicable to citizens of one country. So then I envisage that unless things go horribly wrong in the Supreme Court, that there will be a response needed by UK courts. This could be, and I'm skimming through this in the interest of time here, this could be through interpretation in various forms, but perhaps more far-reaching for UK courts looking more directly to international law, including the ECHR, including the other international human rights instruments. And to some extent, we saw that already in the Supreme Court judgment on the Rwanda plan, the AA Syria case, where the Supreme Court, so basically reading this judgment, the Supreme Court goes through various international instruments at great length through looking at discussing the customary law, prohibition of refoulement, and then there's also the ECHR. That's how it comes across. Yeah, and this is a way, looking at multiple sources for the same human right, same protections, to build resilience. You can't get rid of the right, and you can't get rid of customary international law anyway. The second pathway is to give more effect to unincorporated human rights treaties, which was basically all human rights treaties other than the ECHR. And the UK is a dualist country, and the argument for dualism is the royal prerogative, the law of the land should be determined by Parliament, so international law that's not been kind of approved by Parliament should not create rights and obligations on individuals, should not be the law of the land. But as Lord Kerr, in the dissenting opinion in SG and SSW, the Secretary of State for Works and Pensions, has said, this rationale doesn't really apply for human rights treaties, because the function of these treaties is actually to bind the executive power. Yeah, so the protective thrust is in favor of the citizen against the executive. And he does and some nice quotes, but he says it seems to me entirely logical that that a UK citizen should be able to invoke these rights to which the government has committed on the international plane. So sort of legitimate expectation or a double argument. So the third, more application, direct application in the domestic sphere of international law, both customary and law and international treaties. And the third, and I'm very conscious I have the expert on the topic here on the panel, is the development of common law constitutional rights. Now, the common law does of course evolve and can evolve, and it can without problem, I think, look at international human rights law, including the ECHR. It can still look at EU human rights to substantively inform how it's developed. And just for the EU lawyers here in the room, this has very much resemblance to how EU human rights developed in the early days, through general principles drawn from the constitutional traditions of the member states. So it replaced general principles by common law, and you kind of get the idea. So to sort of sum up this part, so resilience can lie in layers and relying on multiple sources. It can lead to an internalization of external instrument, in particular through the common law, but it's naturally reliant on courts. And that is a difficulty, and you have referred to this, reliance on courts in the situation, on domestic courts in the situation where they're already vulnerable in the situation of an uncodified constitution. The enemies of the people kind of sums it up ad extremis. More so, international law that I suggest should be incorporated is in itself under strain. Yeah, we can just look in the newspaper every day, but also there has been a backtracking in the UK courts, in the Supreme Court, and to what extent international law, and in particular international law, customary international law, is applied automatically in the UK. So that there are counter trends which kind of contradict that the realism of the trajectory. But I would argue this is not a reason to give up. Yeah, these are questions which go beyond the constitutional design. They go to the political, social, and cultural context and the constitutional culture. And I think I may be at the end of my time, but just as to conclude, and I'm summing up the rest of my presentation, we have discussed a lot, so wider considerations. So my outlook on wider consideration. I wanted to highlight a further element of dialogue that we haven't discussed so far. We looked so far at the vertical dialogue between Strasbourg and the member states, and in reverse. What we haven't looked at is at the horizontal dialogue between the courts of states and within the ECHR system, but also increasingly beyond. And if you just look at the recent climate change judgments, when new ground is broken, courts look very much what other courts do. Yeah, and so the transnational dimension of dialogue is a possible source of resilience, but can of course also be a possible source of contagion. So what do we do with this? And I would like to see much more happening in terms of awareness, acknowledgement of the systemic character that both international law creates, but also that the convention system in particular has created. Yeah, so the ECHR is not just a backstop for each individual state. It is a system that you could describe as a system for mutual safeguarding of protection. So kind of the idea, one goes up and one goes down, and that in itself provides safeguards. So I leave it at that with view of time, but thank you very much for listening.
Okay, so our final speaker in this session is Merris Amos, and Merris is going to talk about constitutional resilience through story and narrative.
Great, well, thank you very much. And it's kind of continuing on from this morning. So I'll talk for about an hour because there were so many things that were raised, and I've got all the answers, but not until the end, unfortunately. So everyone likes a good story, and often a human rights story is a really good story and a really engaging story. It might be the story of a family who used human rights law to secure an investigation into the death of a loved one, or how human rights improved access to abortion, or how human rights led to justice for the victims of a terribly bungled police investigation. So these human rights stories can be very powerful, but they also have the potential to bring down the very instruments and institutions which gave them life. In the UK, storytelling has a very particular importance. Human Rights Act has no special protection from repeal, de-ratification of the ECHR. There's also no special protection against that. 25 years of the Human Rights Act have given rise to numerous stories that have been used to both support and undermine the Human Rights Act. And I think we got the sense from this morning that currently the vast preponderance of stories are from those seeking to undermine the Human Rights Act and to de-ratify the ECHR. Supporters have a fairly strong foundation. Of course, we still have the Human Rights Act, despite numerous attempts to get rid of it, and still a contracting state to the ECHR. But for how long, I think is probably in quite serious doubt. This connection between storytelling, constitutional change, constitutional resilience has been discussed previously. It's quite a big issue in US scholarship, but it remains fairly underexplored in the UK. So today I'm going to try to address that gap, kind of glossing over the deep philosophical theory, but you will get a bit of that. So human rights stories and narratives. So most simply, we could say a story is just an account of events, the things that occurred or are believed to have occurred in the past. It doesn't have to be true. Lots of great stories are works of fiction. But this simple account of a story doesn't really capture what I have in mind. Jerome Bruner, a US scholar, defines a story as beginning with some breach in the expected state of things. Something's gone awry, otherwise there's nothing to tell about. The story concerns efforts to come to terms with the breach and its consequences. And finally there's some kind of outcome or resolution. What makes it this story is that there's been some breach in the expected state of things and something will be done about it. Narratives are the result of making connections between lots of different stories. Stories are just stories. So fortunately, the former Lord Chancellor has given us a really good example in her speech at the Council of Europe in June 2025. One of her narratives was that the application of human rights is out of step with common sense. And this was supported by two stories. The first was the traditional story, foreign nationals who have committed serious crimes are not being removed as they've invoked the right to family life. And the second was that dangerous prisoners have been invoking Article 8 to block prison staff and putting them in separation centres. Neither, can everyone hear me? Because I wasn't using the microphone. Neither is a very good story. Both are very short. Both lack further details. We've heard it all before. But these are human rights stories nonetheless. She's told the story of a breach in the expected state of things. Foreign criminals and prisoners are using human rights law to their benefit. But not to worry, she's going to do something about it by seeking reform of the ECHR and clarifying the meaning of Article 8 in national law. So stories and narratives are a very serious business. Even fictional stories can give shape to things in the real world. And Charles Taylor's observed the way that ordinary people imagine their social surroundings is carried in images, stories, and legends shared by large groups, even the whole society. We have a sense of how things go, but this is interwoven with an idea about how they ought to go. And a recent example of the power of story is the TV drama, Mr. Bates versus the Post Office. And that's obviously the fictitious characters there. So Robert Cover, in his well-known article from 1983, explained this importance of narrative to the meaning of law. No set of legal institutions or prescriptions exists apart from the narratives that locate it and give it meaning. This normative universe, or the nomos, establishes paradigms for dedication, acquiescence, contradiction, and resistance. And the resulting interpretive commitments determine what law means and what law shall be. We can control the laws that Parliament passes to some extent, but these narratives are radically uncontrolled. And it's undeniable that these stories and resulting narratives have an impact on constitutional resilience. Scholars in the US have convincingly shown that when the text of a constitution is unable to assimilate new narratives, the constitution is changed. And that's just not thinking about judicial interpretation, but it could also be an impact on the legislature, the executive, those outside the state, the legal profession, civil society, media, and the electorate. There are stories and narratives which both instill constitutional resilience, and there are stories and narratives which undermine the Constitution. So these stories of resilience, in theory, might include a strong origin story, something that provides inspiration even after the passage of many years, instantly reminding everyone of why it was fought for and what its loss would entail. There may be stories of survival in the face of adversity and cautionary tales describing the difficulties before the change and what might happen if we were to return to those times. Crucial to resilience are stories showing how the Constitution has helped the ordinary person. Now, the Office for National Statistics tells us that a large proportion of the UK population are concerned about the cost of living, the NHS, and the economy. It might also be a story about how the Constitution helps the weak stand up to the powerful, or how the Constitution has healed injustices of the past and secured a better future. By contrast, stories and narratives undermining the Constitution will portray certain groups as enemies who are not deserving of protection. The Constitution is a threat to security, putting us all in danger and possibly leading to the downfall of the state. Or it may be claimed that the Constitution just leads to incomprehensible outcomes, lacking common sense, and that the system is completely broken, requiring a reset and a return to the time when things were much better, times when the UK was great. So thinking about stories and narratives of resilience in relation to the Human Rights Act, you can see that the resilience side is a little weak. It doesn't have a strong origin story, or at least one that is frequently told. I have put a reference there to Charter 88 because I was reminded recently at an event that there is quite a significant history, but one that wasn't really capitalised on by Labor government. In 1996, Labour Party explained its plans for the Human Rights Act as essentially something to avoid further embarrassment in the European Court of Human Rights. It did win the 97 election with a huge majority, but basing this origin on democratic will is quite difficult, given that the Conservative Party also won an election in 2015 with a promise to repeal the Human Rights Act. Once in office, the Labour government didn't add very much. There was no formal widespread public consultation. The case remained for the Human Rights Act as it was pre-election. But of course, there were and there remain these efforts to borrow from the far stronger origin story of the ECHR. Part of the Allies' programme to reconstruct durable civilization, the UK played a major part in drafting, and so on. We've heard all of these stories. Its origin story might not be strong, but I think it's hard to deny that the Human Rights Act has a fairly impressive survival story, which we've heard quite a bit about today, and that's often overlooked. Since coming into force, it's been threatened with repeal, amendment, yet after 25 years, it remains substantially in place, relatively unscathed, outlasting David Cameron, Theresa May, and Dominic Raab. Also supporting resilience are these cautionary tales, and the case made for the Human Rights Act in the late 1990s was full of cautionary tales about the poor record of the UK before the European Court of Human Rights and how that would only get worse. Now that narrative was really strong because it was supported by a steady stream of judgments from the European Court about the UK, many of which made for really excellent stories. Cautionary tales continue to be told, but we now have very few judgments from the European Court either for or against the UK. Stories showing how the Human Rights Act has helped the ordinary person are crucial to resilience. Cost of living, NHS, and the economy are most important to people, according to Oxford National Statistics, followed by immigration, crime, climate, and the environment. But the Human Rights Act protects predominantly civil and political rights, and therefore has a very limited impact on cost of living, the NHS, or the economy. There are numerous examples of the Human Rights Act actually failing to offer impact in those areas: bedroom tax, benefit cap, and the recent claim about cuts to winter fuel payment. By contrast, the Human Rights Act has had a significant impact on immigration and crime, although the prevailing narrative is not that it's helping the ordinary person, but that it is acting contrary and undermining the interests of the ordinary person on those issues. One of the few issues where the human rights stories can have a really positive impact is climate change and the environment. And one of the biggest recent stories about resilience, as contributing resilience, I think, is the climate judgment of the European Court in 2024. Undermining the Human Rights Act, there's no shortage of examples. The Human Rights Act rewards enemies who are not deserving of human rights protection. And from the very start, this has been fed by stories about those who have committed crimes but resisted deportation. 2008, Abu Qatada, 2010, Mohammed Ibrahim. Stories about prisoners benefiting from the protection of human rights are also feed into this narrative. Human rights are a threat to our security. It started in 1995, seriously with the judgment of the European Court in McCann, and has continued following the attacks of September 11, 2001, and the terror attacks in London, 7 July 2005. It's not original for the former Lord Chancellor to claim that human rights are an affront to common sense. And there's all these short reports over the years that have a surprising longevity. You remember from 2004, the 9 Afghan hijackers. From 2011, Theresa May's foreign criminal resisting deportation because of the pet cat. And finally, we have the idea that the system is broken. And this never goes away. I mean, leading to quite a lot of boredom, switching off for those who follow the debate and are interested and heard it all before. And for those new to the discussion, I think it can lead to very much a lack of confidence in human rights law and institutions. Right from 2006, Conservative Party promised to rip up the Human Rights Act. In 2012, the Commission on a Bill of Rights. In 2019, the Independent Review of the Human Rights Act. 2022, the Bill of Rights, which was withdrawn in 23. And in 2023, a new approach, just suspending the Human Rights Act in relation to the laws that you mentioned. So What are the answers? I appreciate that it's quite difficult to come up with the answers, but I have a few more answers than were offered this morning. So we could say that after 25 years, there's fairly serious blows have been done to the Human Rights Act in the minds of the general public, and also to the status of the European Convention on Human Rights. So is there really any point trying to redress the imbalance? I think history reflects that you're not actually stuck with the same narratives in perpetuity. New stories can change the narrative. The Human Rights Act was finally passed by Parliament in 1998. Will it take another 25 years to get back to those times? How might that happen? So I think a first step is for those who are supporters of the Human Rights Act and the Convention to appreciate the importance of story and narrative to constitutional resilience. And that's something that's really clearly understood by those who are seeking to undermine the EHRA and the ECHR. Silence really isn't the answer, nor is joining in, which I'm really quite depressed to say. The point concerning the need for better public education on human rights has been made again and again. In 2021, the Independent Human Rights Act Review recommended developing an effective program of civic and constitutional education. But this has never been properly acted upon. Second, to increase stories and narratives contributing to resilience. Tell the real origin story, the real history of what led to the Human Rights Act, not the one that was curated by the Labour government in 1997. Tell the story of the Human Rights Act's survival in the face of numerous attacks and commitments to repeal it. Each attempt to kill it shows again and again why we need it. Increase the flow of stories that the Human Rights Act is for you. And also crucial, moving beyond judges and judgments and try to tell the story of the Human Rights Act and the work that it does behind the scenes. You might remember the 2015 Act for the Act crowdfunded campaign, the work of the British Institute for Human Rights, Amnesty, and the charity Each Other. Telling these relatable human rights stories is possible. And going back to judgments, whilst these are now few and far between, there are some which make for an engaging story. And you can even ask ChatGPT to draft a dramatic script, and you can try and sell it to ITV. I was thinking about that myself. I would give you some UK examples, but as I also think we've been talking about in Code today, is there's not many great human rights stories coming from the UK courts at the moment. European Court, though, and its judgments about other states provides a really steady flow of great stories. And I think it's really important to tell those stories and say, well, this is what can happen in states which don't have really good human rights protection. You can also directly confront these stories and narratives undermining the Human Rights Act. And I think two are particularly vulnerable. Are all human rights judgments in this country really an affront to common sense? You might not agree with the judgments of the UK Supreme Court, but it's very difficult to argue that they're not delivering common sense outcomes if we assume those are in support of government policy. The second vulnerable narrative is this system is broken narrative. It's so many internal disagreements, reviews, even a failed Bill of Rights before Parliament. All that is broken is those that are seeking change. After 25 years, it's really time to stop taking advice, and this is directed to reform, from the Taliban, and wasting resources on a policy that will never be implemented, and to admit defeat. Finally, to focus on the storytellers. There are stories to be told, supporting narratives of resilience and combating narratives undermining the Human Rights Act. But without anyone to tell it, it won't be told. And that's what Stuart raised this morning. Who are you expecting to do this? There is no shortage of storytellers seeking to undermine the Human Rights Act. Nigel, Kemi, Shabana Mahmood, Suella Braverman, policy exchange is prolific. You can't leave these stories just to be told by judges. Judges need prime ministers, government ministers, they need the Equality and Human Rights Commission. They need journalists, NGOs, politicians, and academics to help tell these stories that they are written. So I am almost out of time. I have 1 minute, so very quick summary. So for those seeking to undermine the Human Rights Act, the stories will just keep on coming, and they all end in the same way. Repealing the Human Rights Act, de-ratifying the ECHR. I think these stories and narratives have very clearly entered public consciousness now, making it very hard to separate the Human Rights Act and the ECHR from them. And we're possibly approaching a point where neither can actually withstand the onslaught. Silence, joining in, are not the answer if you do support the Human Rights Act and the ECHR. New stories can change the narrative, but it will be a very slow process. Relatable human rights stories are possible, and those we can all think about the potential story value of the latest judgment from the High Court, Court of Appeal, Supreme Court. Those seeking to undermine the Human Rights Act have no difficulty in discussing the judgments that illustrate the narrative. The opposing case, I think, is also possible. Human Rights Act needs more stories, new storytellers, something to which we can all contribute. So thank you.
Thank you very much to all three of our speakers. We've got a little bit of time now for questions. So like earlier, we'll take 2 or 3 and then open it to the panel. I think Stuart was first.
Thanks. Stuart Wallace, University of Leeds. I suppose my question is more directly at Katja than the others, but please feel free to comment if you have an opinion on it. But I think at one point you mentioned that notwithstanding something, you know, crazy happening at the Supreme Court in relation to the Reed Dillon appeal. And as soon as you said that, I was like, something crazy is going to happen at the Supreme Court in relation to the Reed Dillon appeal. So do you not fear that the Supreme Court in its current composition would be much more likely to drag the Windsor framework back into alignment with the rest of that base of human rights law within the UK, rather than allowing it to go its own way and then trying to adapt the rest of the UK to it?
I think that just in front of Stuart, there's another question.
Good evening, I guess. My name is Edward Perez, PhD candidate, University College London. I actually have questions for all 3 of you. So I'll start not in order because I think I can merge the ones to Professor Colm and Professor Merris together. So first, Professor Ziegler, if you could, at least for 1 minute, elaborate a little bit more on the idea of the horizontal dialogue between courts as part of developing democratic resilience, because and in that side, I'm curious about whether you see the European Court also within that horizontal dialogue, and or somewhere in between, vertical, horizontal, or something, depending on what's the case. I'm just curious about what's the extent of how you envision that horizontal dialogue in these types of questions, especially since one of the key problems with the European, not problems, challenges with the European Court is actually the legitimacy of these types of the decisions. And so to Professor Merris and Professor Colm, they're together because in the end we're talking about narratives and how we're repoliticizing, or how the future seems to repoliticize rights. And my question is, how do you envision in this repoliticized version of rights, or in this narrative construction, counter-narrative construction of rights, how do you envision the difficult rights, the rights of the peoples who are imprisoned, the rights of migrants? Should we, for the benefit of protecting the Human Rights Act or protecting more rights, leave these more controversial types of topics aside, or should we assume the political cost? Because not only as an academic, but also as a person who did like some human rights advocacy before, one of the biggest challenges is remaining consistent. And we are expected to, if we are in favor of rights, we're in favor of all rights. So how can we manage, how do you think we can manage these narrative challenges, especially in a forum that is highly politicized now?
Thank you. That was quite a lot, so let's pause there and,
sorry.
no, that's fine, but before we lose track of the questions, I'll invite people to respond. Katja, do you want to start?
Yeah, I have only started listening into the Supreme Court hearing, so the one of the central issues is whether there's direct effect of Article 2 of the Windsor Framework, and I mean, famous last words, but I think this is crystal clear to me that it is. Yeah, the Windsor Framework is part of the withdrawal agreement. The withdrawal agreement has the same status as in the EU, so direct effect and supremacy. So I think that yeah, of course, one never knows, but to me, it would be crazy to deny that. And of course, that could then, of course, be also picked up between the EU and the UK for clarification. And that's perhaps something a domestic actor, let's say, would not necessarily want, right? And then I think the other issues that are at stake then, yeah, whether the direct effect kind of rolls on in the chain, there's perhaps a little bit more wiggle room. Yeah, but that perhaps doesn't fall entirely into the kind of crazy category. But the interpretation of 2 paragraph 1, I think, is key for any rights more extensively flowing from the Windsor Framework. The second question from Edward and the elaboration on the horizontal horizontal dialogue. So I haven't really thought of the European Court of Human Rights to be within this but of course it relates to the European Court of Human Rights judgments as well. So I'm not sure whether the question was how to use that as a tool. If that was the question, I would say that any actor in national courts, but also political actors, need to be more reflective of the systemic impact statements have and rulings have. And reason, perhaps not less so the outcome, but the reasoning has on other on other courts in the system. Yeah, if a UK court says we put like in the Al-Haq case, the F-35 carve out, the court basically said everything that is in the royal prerogative, foreign policy is removed from scrutiny, which is a much more restrictive view than we generally have to human rights. So even if the reasoning should be more sort of cognizant of the potential repercussions. Now, one could say this isn't the job of the court; they just should resolve the case. But I think if constitutional resilience needs to be built, then this needs to be thought of. This is both in the outward dimension, but also in the receiving dimension, because one never knows when one needs it. Yeah, that's the idea. Perhaps in the interest of time, I stop. I couldn't.
Merris, Colm, do you want to respond to Edward's other question?
Well, as an Australian, I had a lot of experience with working with the Human Rights Commission, and the only thing anyone ever wanted to talk about was migrants and asylum seekers. And we were actually told by the commissioner not to mention them, just to talk about human rights for everyone else. But that's not the answer. You have to talk about it. Of course, you have to include the difficult cases, and you have to try to explain with human stories. And there is a journalist, I can't remember her name now, that's working on human stories, migrants and asylum seekers coming to the UK. Do you remember her name? written a book, it's a very good book. So humanizing that experience, because people don't often understand the human stories behind that. It also reminds me of all those years that many of us in this room had to talk about the prisoner voting judgment. You would go to a conference and all anyone wanted to talk about was prisoner voting and what you thought about that. So you have to say, this is what I think about prisoner voting, but it can't be the only thing we talk about.
Okay, thanks. Very briefly, on dialogue. Dialogue is part of the mechanisms, the framework of mechanisms that make multi-layer European rights protection work, whereby you reconcile the claims to supremacy of the national constitutional system with supranational rights adjudication. If the UK wants to remain committed to the ECHR, then dialogue will continue to be a very important smoothing mechanism. But for those who want to exit, dialogue is never going to satisfy. And I think this is why I think we've reached a significant break point here, where answers like a good dialogue exists are not going to satisfy a lot of politicians on the centre right in a period where ECHR exit is a loyalty test. So I think a lot of those mechanisms will only continue to thrive and smooth the way if the political consensus for the UK, if the UK, for some, you know, the way politics develops, remains within the ECHR framework, remains reasonably well embedded in the ECHR framework. Secondly, Northern Ireland, I haven't said anything about Northern Ireland. I didn't mention it once. I'm very good about this. It is interesting to me, the Wilson report relied completely on policy exchange paper saying there isn't a Northern Ireland issue here. The policy exchange paper, 65 pages, doesn't engage with any of the arguments made by the Irish government or Irish nationalist parties with why the ECHR is an integral element of the peace process. 65 pages, no engagement with the opposition argument. There's a clear legal error on page 35, which nullifies much of the report. The reaction in Dublin and Belfast has been bemusement. I didn't talk about Northern Ireland's contribution to the future of rights protection in the UK, because my sense is that if ECHR exit happens, Northern Ireland will end up with an entirely separate human rights regime involving ECHR protection, either through some sort of co-sovereignty mechanism or through some sort of British-Irish International Court that continues to apply ECHR standards. And where maybe I disagree with Katja is that I think what's going to happen is that none of that is going to wash back into the rest of the UK. Northern Ireland will, like what happens under the Windsor Protocol, increasingly become a free-floating part of the UK going off in another direction. I find it remarkable that the Conservative and Unionist Party don't seem to be worried about that, but who am I to judge their political priorities? Finally, on the counter-narrative, a key counter-narrative, which I think isn't being put forward, is talking about the alternatives, because it's very easy for attacks to be launched on the ECHR as the status quo. But once you start mapping out what UK law would look like in a transformed status quo, we get into interesting territory. Are we really going to oust judicial review of all immigration and asylum decisions, as proposed yesterday by Lord Davis in the House of Lords? That's going to get a massive backlash. Are we going to effectively eliminate rights review of ministerial decisions under family life, breaking up families for deportation, deportation back to situations of real risk? Is Parliament going to legislate? I was discussing this with a member of the House of Lords yesterday. In my view, Parliament will want to make this an explicit decision if it's going to make it work. Is Parliament really going to legislate for family transfer back to Afghanistan? Is Parliament really going to say that a ministerial decision to deport a 50-year-old father of 3 UK national children is going to be immunized from judicial review? It might, in which case we're in a quite radical anti-human rights paradigm. But I think if you start formulating the legal alternatives to the status quo and how this might cash out in concrete terms, many of those alternatives start looking less attractive or become constitutionally very problematic. So I think people should be asking, well, if you don't want the ECHR, what future legal situation are you actually envisaging? And so far, the answers we've heard on that from the Tories and Reform have actually been a real mess, even allowing for their policy problems, like the collapse of the policy on indefinite leave to remain, which at one point, Chris Phillips' tabled private members bill was suggesting that 4 million people in the UK could be legally deported. All right, that was the proposed legal situation at one point. They've rolled back from that. And I think pointing out those problems may be an important part of any counter narrative.
Thank you. We're out of time. If I can just abuse my position as chair then, add a tiny footnote to what Colm has just said. It occurs to me that something that I think has been sort of in the air today, but which we haven't maybe fully sort of drilled down into, is this question about what is it that critics of the ECHR want and what is it that they're objecting to? Are they objecting to a specifically European or transnational human rights regime? Or is that in fact merely a Trojan horse for arguing against judicial protection of human rights, full stop? And I think for a lot of them, I think that the one thing and the other join together seamlessly. And so that question about what comes next, I think is absolutely crucial if we are moving beyond the ECHR. Well, before we move on to the final speaker, let's thank our three panelists once again. Thank you.